My name is Michael Young, and I'm a lawyer who handles contested estates in Texas. What is a contractual will? Well, essentially, it's an agreement between two people to dispose of their estates in a specified manner. Why would you want that? Well, take, for example, a married couple, and let's assume that they have a standard provision that says that all of the assets of the first to die will go to their surviving spouse. And then let's assume that they have children that are entirely of the same marriage, and logically, for the most part, they would want their surviving children to receive the assets once the second spouse dies. But what happens if they're afraid that the second spouse will then remarry, and there will be a pressure or an inclination maybe to cut in somebody else from the second spouse's family into the assets, or leave the entirety of the assets to them? Is there a way for them to address it? Yes, there is. Texas law does provide a method to execute joint and contractual wills. So, first important thing is executing a joint will alone is not enough to have an enforceable contract. Texas Estates Code section 254.004 specifies that in order for a will to be a joint contractual will, there has to be certain requirements that are met. The first is that it has to be in writing. It has to be a will and meet the formality requirements of a will. But beyond that, the will must explicitly state that it's contractual, that the two people executing the will are in agreement that it's a contractual will. It also must state the provisions of the particular contract. And typically, like I say, will be for spouses that all the assets will go to the surviving spouse, and then after that, the spouses will agree where the assets go when the second spouse dies. That needs to be explicit. It's not enough that the parties execute a joint will. You must state that it's a contractual will, and you must state the specific provisions. The Texas courts do not want to have to guess as to whether or not this is a binding contract. They want to see the explicit terms in the will. So where do you go if you want to execute such a will? It's important that you go to an experienced estate planner. And then what happens if there's a dispute down the road as to whether there is an enforceable will? Or what happens when the second spouse does a will that's contrary to the earlier contractual will? If that happens, it's very important to come to see someone like me. I'm not an estate planner. I am an estate litigator. I get involved if there is a dispute. I'm the person you call, or someone like me who's an experienced estate litigator, if you believe you have an issue regarding the enforcement of a contractual will.